I need Radu, please. All right, this is cause number 23 DCCR 1467 and 23 DCCR 1468. And ma'am, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Romanian, Romanian to English, so help you God?
I do, Your Honor.
Thank you, ma'am.
Thank you.
Sir, are you Radu, Paul Radu?
Vă numiți Radu Ion Radu?
Da, onoratul.
Yes, Your Honor.
And Mr. Radu was previously in court and entered pleas of guilty to unlawful interception or use of electronic communication and credit debit card abuse.
Ați mai fost în curte înainte și ați pledat vinovat la interceptare electronică și la abuz.
Da, onoratul.
Yes, Your Honor.
And the pleas were open to the court. There was no agreement. And I've received the pre-sentence report and reviewed it.
Și v-ați lăsat cumva ați căzut de acord ca doamna judecătoare să hotărască pentru că nu ați căzut la o înțelegere cu partea cealaltă. Doamna judecătoare a analizat discuțiile și raporturile.
Da, onoratul.
Yes.
Has Mr. Macon and Ms. Malfini, have you both had an opportunity to review that?
Yes, Your Honor.
I have, Your Honor.
And Your Honor, I've had the pre-sentence report translated to Romanian, and my client has read it, and he has no objections or clarifications to it either. And I would like to put into the court's file the translated pre-sentence report.
All right, thank you. Any objection to that? That would be put into as defense one. So, Mr. Radu, you were able to read and go over the pre-sentence report in Romanian, correct?
Și avocatul dumneavoastră a spus că v-a arătat raportul deja tradus în limba română și dumneavoastră n-ați avut nicio obiecție la el și ca urmare îl depune la dosar ca și probă. Partea cealaltă a fost de acord și doamna judecătoare vă întreabă dacă este adevărat că într-adevăr ați primit raportul tradus în limba română și l-ați citit.
Da, onoratul.
Yes, Your Honor, it's true.
All right, thank you. And Ms. Malfina, does the state have any objections or corrections?
No, Your Honor.
Okay, Mr. Macon, I'm going to allow you to proceed with argument. We can do this two ways. Have you already discussed with your client what your argument's going to be, or do we need to go slow and have that translated?
I think we could go slow. I'll be very brief, Your Honor.
Okay, go ahead. And if you'll just do it,
Okay,
a
Your
little
Honor,
bit at
I
a
think,
time.
Once you've read everything in my client's letter that he sent to you, it's obvious that he was taken advantage of by the ringleaders of this. He's definitely sorry and apologizes to the court.
Go ahead, ma'am.
Deci, avocatului dumneavoastră îi se dă acum ocazia să prezinte argumentele. Doamna judecătoare l-a întrebat pe avocat dacă deja v-a prezentat argumentele sau vrea să le spună pe rând și eu să traduc. Avocatul a spus că preferă să prezinte argumentele acum pe rând și eu voi traduce. În prima situație, domnul avocat a spus că doamna judecătoare, așa cum ați văzut, clientul meu v-a trimis o scrisoare. Este clar că clientul s-a profitat de inocența clientului meu și acesta este un fapt pe care clientul meu îl regretă.
Da, onoratul. Și îmi pare rău și regret ce am făcut.
I'm really sorry and I deeply regret the whole situation.
All right, thank you. Anything else, Mr. Macon?
No, Your Honor.
Ms. Malfini?
Although I have been in touch with immigration, and it's my understanding that Mr. Radu is going to be deported back to Romania as soon as he's available.
Okay, that's my understanding. There's immigration hearing pending from California, New York, and now here, as with regard to immigration. Is that everyone's understanding?
Yes, Your Honor.
Go ahead, ma'am.
Doamna judecătoare l-a întrebat pe avocat dacă mai este ceva, dacă mai vrea să mai zică ceva și a spus că nu, doar vrea să îi spună că știe că Serviciul de Imigrație urmează să vă preia și să vă deporteze. Doamna judecătoare a verificat dosarul și, într-adevăr, vede în dosar că prima dată în California, apoi în New York și apoi aici unde vă aflați acum, într-adevăr, Serviciul de Imigrație a pus, cum ar veni, o oprire pe caz, nu puteți fi eliberat și veți fi preluat de către imigrație.
Da, doamnă.
Yes.
In addition, I want to make sure, it looks like there are pending felony offenses in Missouri and Ohio for similar offenses. Is that correct?
De asemenea, a observat că sunt în așteptare cazuri de natură criminală pentru aceeași acuzație în Missouri și în Ohio. E adevărat?
Nu știu.
He doesn't know. He's not aware.
Probabil da. Probabil.
Maybe he's not aware of this.
Okay. All right, Ms. Malfino, you may proceed.
Judge, the defendant's criminal history indicates that this was not an isolated type of incident. I know Mr. Macon phrases him as the being deceived by the ringleaders of this, but I believe he was.
If you'll step up, the microphone is either here or there so that she can hear you and translate, and go slow and make a pause for her to translate, please.
Acuzarea a spus că, așa cum reiese din dosar, ăsta nu e un incident izolat și asta nu arată că e doar o greșeală.
Go ahead.
Judge, it obviously makes no sense to consider probation in this case based on all of the immigration issues. That's why we defer to the court to go open. Mr. Coleman would ask the court to consider a period of 10 years.
All right, thank you. Anything else, Mr. Macon?
We'd ask for something less than that, Your Honor.
Deci, acuzarea a zis că e clar că nu se consideră o greșeală și crede că eliberarea pe cauțiune și la domiciliu iese din discuție. De asemenea, și ei solicită la fiecare cap de acuzare câte 10 ani. Avocatul dumneavoastră a zis că ei cer totuși ceva mai puțin. 10 ani e prea mult.
So Mr. Radu, I appreciate what your lawyer's arguments are.
Domnul Radu, vreau să vă spun că apreciez argumentele avocatului dumneavoastră.
But the fact that you have pending immigration hearings from California, New York, and now you're in Texas illegally.
Dar faptul că aveți procese de imigrație cu California, New York și acum Texas, aflându-vă aici ilegal,
And that it looks to me like in the same year as this offense, you also were in the state of Missouri and Ohio, potentially committing similar offenses.
și de asemenea faptul că în decursul aceluiași an, pe lângă acuzația asta, dumneavoastră v-ați aflat și în statul Missouri și în statul Ohio, unde ați făcut, sunteți acuzat de aceleași fapte,
which would make no sense for the argument that you were somehow taken advantage of on what happened here in Jefferson County.
ceea ce arată clar că, de fapt, nu s-a profitat de dumneavoastră, cum ați menționat acolo în Jefferson County.
So at this time, I'm going to find that you entered your plea of guilty in each case freely and voluntarily.
În cazul acesta constat faptul că v-ați declarat vinovat în mod liber și voluntar.
In cause number 23, DCCR 1468, find sufficient evidence to find you guilty and find you guilty of credit debit card abuse.
Și în cazul 23 DCC 1468 vă găsește vinovat de abuz de credit și debit card.
sentence you to a term of 2 years in the state jail prison,
Vă condamnă la 2 ani în închisoarea statului.
you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Veți primi credit, deci vi se va lua din ăștia 2 ani în considerare perioada pe care deja ați petrecut-o în închisoare, conform legii.
And cause number 23, DCCR 1467, finds sufficient evidence to find you guilty of unlawful interception, use, or disclosure of electronic communication.
Și de asemenea, în cazul 23 DCC 1467, sunt suficiente dovezi să vă găsesc vinovat pentru interceptare de dispozitive electronice.
And at this time find you guilty of that offense.
Și vă găsesc vinovat de acea acuzare.
And I'm going to sentence you to a term of 15 years in the Institutional Division of the Texas Department of Corrections.
Și vă condamn la 15 ani în instituția Departamentului de Corecție din statul Texas.
You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
De asemenea, și în această condamnare veți beneficia de credit pentru toată perioada pe care deja ați petrecut-o încarcerat, conform legii.
And Mr. Radu, I understand that the state made a recommendation of less time than that.
Și înțeleg că statul a făcut o recomandare de mai puțin decât ce v-am dat eu.
But the fact that you've been all over the United States committing these types of offenses while here illegally makes me think that that's not near enough time.
Dar pentru faptul că, în primul rând, ați fost aici în Statele Unite ilegal și în tot timpul ăsta ați umblat prin mai multe state și ați comis infracțiuni, cred că condamnarea mea se justifică.
These sentences will run concurrently, which means together at the same time.
Aceste două sentințe vor curge concomitent în același timp.
I'm going to hand you the trial court certification that shows that these were not plea agreements and you do have some rights to appeal.
Și o să vă dau acces la rapoartele care vor arăta că aceste sentințe nu s-a căzut la înțelegere asupra lor înainte și faptul că le puteți apela.
I have also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition.
Și de asemenea vi s-a înaintat și o dispoziție prin care nu veți putea avea acces la arme de foc și amuniție.
Because of these judgments against you, you're ineligible under Texas law to possess a firearm or ammunition.
Din cauza la aceste acuzații și la aceste condamnări, legea statului Texas vă interzice dreptul de a avea acces sau de a avea în posesie arme de foc sau amuniție.
I have that the document is in English, and Mr. Macon, I will ask if you can please get that document regarding the firearm translated to Romanian for
I will.
Mr. Radu to read.
And I'll be out this Saturday to go over all that with you.
Okay.
Ok. Aceste documente sunt în limba engleză și l-a rugat pe domnul avocat să vi le traducă și domnul avocat a zis că vă va vizita sâmbătă și vă va aduce toate documentele traduse în limba română.
All right, Mr. Rivas, in cause number 25-0021, the state is elected to proceed on the lesser included offense of a Class A misdemeanor, attempted theft of a firearm, from October 18th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Rivas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, attempted theft of a firearm, sentence you in accordance with your agreement to a term of 45 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. All right, sir, are you Dedrick Davis? No. And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Davis, in cause number 24, DCCR 0344, I have a motion to revoke your community supervision. This shows that you were placed on probation May 14th of 2024 for the offense of theft of property with previous convictions, and that was a 2-year term in the state jail prison, and it was probated for 5 years. Is that correct? Answer out loud, yes or no. Thank you. It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department April 4th and April 14th of 2025. And is that true or not true? True or not true? Count 2 alleges that you failed to work at, count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Count 3 alleges that you failed to enroll in services at the Spindletop Center as ordered. And is that true or not true?
That's true.
We'll abandon, state will abandon count 4, no,
And 5 or not?
not 5.
Okay. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
It's true.
All right. Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Davis is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, or your plea is of true, freely and voluntarily. Find that you're mentally competent. Find counts 1, 2, 3, and 5 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You were handed, and I talked to you about the firearm, not being able to possess a firearm when you first got your probation, right? I've given you another copy of that. Make sure you read it and you understand the rules with regard to not being able to possess a firearm. All right? Good luck to you. You can go back with the bailiff. All right. Are you Alvin Lewis?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
You will, Your Honor.
Which one are you doing?
3. I have both of them. Well, I can do the other one too.
I just clicked the other one. Don't worry about it. All right, so in cause number 19-32086, I have a motion to revoke your community supervision. Shows that you were placed on probation November 12th of 2019 for the third-degree felony offense of failure to register as a sex offender. That was a 10-year term that was probated for 10 years. Is that correct? And then in cause number 21-37343, I also have a motion to revoke, in this one, to revoke your unadjudicated probation. Shows that you were placed on probation June 21st of 2021 for the offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? Each of these motions allege that you violated your probation, and the state is going to abandon one, correct? Is that what you said?
No, Judge.
Oh, he was arrested for it. Okay.
Correct. I just wanted the court to know the case has not been brought to that.
Okay. Count 1 alleges that you were arrested for the offense of possession of drug paraphernalia on April 22nd of 2025. And is that true or not true?
True.
Count 2 in each case alleges that you possessed a drug, marijuana, on April 22nd, 2025. And is that true or not true? And then count 3 in each of your cases, or both of the cases, allege that you are behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probations, but order that you enter and successfully complete the substance abuse track of the ISF program. Is that your understanding? So with regard to that evading, I think we're less than a year out. And so I think with that program, I'm inclined, if I'm going to go along with this, to extend that for a year or so.
Thank you.
Yeah, I mean, you're on 10 years for the other one anyway, but the evading, it was a 5-year probation. And I think based on what's been going on, I'm going to add a year to that, just so you can get through this program and the aftercare and all of that. Does that make sense?
Yes, ma'am.
Okay. You can ask a question.
How many years do I have left on the 10-year?
Look, you're asking me to do math after my morning?
Oh, I'm sorry.
The rest of it.
Yeah. So if you were put on in 2019 and you had 10 years, so that's 2029 for that case. Okay?
Yes, ma'am.
All right. Okay, so state tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, in both of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probations, but I'm not going to do that. I'm going to follow the agreement that you made with the district attorney and continue your probation and order in each case that you enter and successfully complete the substance abuse track of the ISF program. In cause number 2137343, I'm also going to extend that probation by 1 year as well. These were agreements. I'm going to hand you in each of your cases trial court certifications that shows you've waived any right to appeal. I hope you understand the opportunity that you're being given today. Take advantage of it. Do what you need to in ISF to get the tools so that you can be successful and not end up in prison. Because if you end up back here on another motion, that's very likely what will happen. All right, give me just a second. One of them's printing. I gotta get the other one.
Thank you.
Yes, sir. Good luck to you. Mr. Parker can bring those back in just a second if you want. Let me get the other one printed. Are you Camden Jackson? And Mr. Jackson, in cause number 25 DCCR 0114, you're charged with engaging in organized criminal activity. Ms. Perazo has filed a motion to withdraw as your attorney. And so do you have any opposition to me allowing her to withdraw? Answer out loud. Okay. So Ms. Perazo, I will grant your motion. Mr. Jackson, do you have the funds to hire an attorney?
Just working on it.
You're working on it? So here's what I'm going to do in the meantime because you're in custody. I'm going to go ahead and appoint an attorney. That way you have no lull in representation. Somebody will begin working on your case. If you get someone hired, then they can file the appropriate motions to step in, okay? But you will be appointed an attorney today. Now, before I send you back to the jail, I want to talk to you about this stack of incident reports that I have of how you're behaving in our jail. And I know that one of the things that you wanted Ms. Perazo to do and that she had filed on your behalf that we're not going to take up today is for me to reduce your bond. And I can assure you nothing's going to happen other than your bond being increased if you continue to act like the little hooligan that you're acting like in our jail. I can't even tell you how angry this makes me. How old are you?
Just turned 19.
Just turned 19. Well, let me tell you something. It is time to grow up. because you and the other little 18, 19, whatever y'all are doing in there, you're never going to get out of jail. You're going to end up in prison, and your life is just going to be just like this. And is that what you want? It's not, is it? Cussing at the correctional officers, laying in bed because you don't want to get up, staying up late because you don't, you know when you get to sleep late? When you're at home because you're not in jail for violating the law. That's when you get to sleep late. That's when you get to make your own decisions. You don't get to make those decisions right now. And I get a report every single time you're acting up. And you're going to keep coming in front of me with another lawyer, and it's the same thing. The DA knows about these, and if you think that's going to make them want to be nice and offer you some great deal on your case, it's not. All it's going to make everybody want to do is something worse to you. So starting today, if you think you want something good to come out of your case and you want some possible good treatment and to get out and to be able to live a life like the rest of us, start proving it starting today in jail. Otherwise, it's not going to happen. Do you understand? All right, go back with the bailiff.
Thank you, Your Honor.
Thank you. Mr. Kimler, you have Corey Carter. I thought this was set for a plea.
Well, it was, so they would.
I'll give the court explanation, Your Honor.
It was gonna.
Judge, we discussed what I thought was going to be a solid agreement, and then after reviewing jail disciplinary, I just didn't think the court would approve it. So I upped my offer, which is being refused.
Yeah, just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket today to plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jail write-ups, which I've been provided with, and that the offer was now 6 years and with a 7-year cap, and Mr. Carter's previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you?
17.
17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right? And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man. But you are in felony court like every other grown-up man. And if you make kid decisions and think that horse playing and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And that's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him. to a second degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible second degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range
Okay.
from a third degree to a second degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a second-degree felony instead of a third, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have your case set for trial. We've talked about all that. Do you want to reject that offer and have a jury decide? Okay, then we'll get your case set on the trial docket as quickly as we can. Again, don't get over there and forget what I told you today. It's very important. Do you understand? All right, you're Christopher Bushnell? And so Mr. Bushnell has 2 cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, and cause numbers 25-0112 and 0113. There was previously an agreement motion, a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So, so we're getting close, but here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right? And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th?
No.
You want to take a guess?
No.
Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate?
It's not.
It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse. But it's not. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Where you have a little more. Good morning. Are you Marissa Tibbetts?
Yes, ma'am.
And will your client waive the formal reading of the motion in each of her cases?
She would, Your Honor.
Okay. Ms. Tibbetts, in cause number 1828, well, before we do that, raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Tibbetts, excuse me. I have in cause number 1828754, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2018 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 1828753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct? Each of these motions allege that you violated your probation. Count one in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am. Not true.
Count two in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count three in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count four in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those two are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations, and anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, you can go back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases that are relatively high. I believe they're.
Do you want to file a motion for some, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance.
The defendant entered court hoping for a lighter sentence, but the judge saw the situation very differently. After reviewing the pre-sentence report, the court considered his guilty pleas and the defense argument that he had been taken advantage of by others. But the judge also considered his broader legal situation, including pending immigration matters and allegations involving similar offenses in other states. The prosecution asked for 10 years, while the defense requested less. Then came the final decision. The judge found the defendant guilty of credit and debit card abuse and sentenced him to 2 years. But on the electronic communication offense, the sentence was far more serious, 15 years in the Texas Department of Corrections. The judge explained that the defendant's history and circumstances made the recommended punishment insufficient. The sentences would run concurrently, but the 15-year sentence completely changed the outcome of the hearing.